You're watching Bill on Bankruptcy. I'm Pacchia. We're joined now, as always, by Bloomberg News bankruptcy columnist Bill Rochelle. Can't do the show without him. Be sure to go read his daily bankruptcy column. It's available on BloombergLaw.com and also on the Bloomberg Terminal. The top story, Bill, today is a little bit of a messy situation. The U.S. trustee in New York is taking on law firm Kaye Scholer and financial advisor Capstone. What's the dispute? What case are we looking at? And does this sound like the normal penny-ante disagreement over fees, or is there something bigger here?
Not hardly. The U.S. trustee wrote a 112-page pleading. And I cannot think of another situation.
The pleading was
112 pages. I can't think of another situation where the U.S. trustee has devoted so much in resources to an ethical issue. Money is not inconsiderable. They want Kaye Scholer and Capstone both to disgorge about $6 million each in fees they were paid in the GSC case, which is now largely completed. What this is all about is an allegation of an undisclosed fee-sharing arrangement. The dispute arises because the lead, let's call him partner, from Capstone was not really an employee of the firm as had been represented to the court, but rather, the U.S. trustee says, this chap was an outside contractor. And this, therefore, gave rise to the possibility, as I put it, of this ethical violation by fee splitting between Capstone and the chap who led the engagement. Now, there are two ways to look at this, Lee. You can either say, as the U.S. trustee does, that this is a serious technical violation of the bankruptcy code, or it is just a hypertechnical reading of a statute that should be read more charitably. Ultimately, this is going to be a really tough decision by bankruptcy judge Shelley Chapman here in New York.
Right, it's probably the first time she's faced an issue like this. At the end of the day, Bill, who wins?
Ooh, hard question. Well, I'll tell you what. I'll go by past performance. In New York, at least, you can say with confidence that the U.S. trustee typically loses.
Okay. First up, there were developments in the Lehman Brothers case. What happened?
Oh, very interesting. Lehman is raising an issue that, my friends, I think can go to the U.S. Supreme Court, certainly at least to the Second Circuit. Lehman looks at Section 1146 of the Bankruptcy Code and says that this provision allows them to sell billions of dollars of property after emergence from bankruptcy without paying transfer taxes or real estate taxes. This is a big deal. Now, I suspect, Lee, that as we sit here right now, what they're asking for is an advisory opinion, which bankruptcy judge Peck won't give at this stage. Nonetheless, the issue will arise ripely very soon, probably in the context of the $2.5 billion Archstone sale. So, folks, tighten your seatbelts, because this is going to be a really important case for bankrupt companies coming out of Chapter 11 hoping to pay less in taxes.
And we have developments also in American Airlines. What's happening there?
Yes, absolutely. American up and said, what the market, I think, has been guessing for a while, that the parent company, AMR, is solvent, with money left over for shareholders.
Well, that's good.
Well, this, by the way, is no big surprise. If you read a column of mine back in December, that's exactly what we said. So go back and look at the column in, I think, December 17th for some details.
And we also have some news on statistics. Bill, the numbers for total bankruptcy filings, of course, were down for 2012. How much were they down, and how do things look for 2013?
Good deal. Very material. There were about 1.2 million bankruptcies across the board in 2012. That's a 14% decline from 2011. Business bankruptcies down even more, 22%, and Chapter 11's down about the same, 12%. But on top of that, December had 75,000 bankruptcies just in that 1 month alone. That may sound like a lot, Lee, but the fact of business is that is the fewest in 4 years. Ergo, I don't think it's hard to imagine that 2013 is going to have fewer yet bankruptcies across the board, personal, individual, Chapter 13, Chapter 11, everything else.
Not welcome news for the bankruptcy bar, for sure. Let's do some advance sheets. The Sentinel bankruptcy in Chicago and the Hostess Brands bankruptcy in White Plains, New York, of course, both made law in the week. What do we need to know about the decisions?
Okay, first, Sentinel out in Chicago, decision by bankruptcy judge James Zagel. For securities types, this is really important. This is the first time that a judge at an appellate level, or that is above the bankruptcy court, has found there to be a wide, gaping hole in the so-called safe harbor under Section 546 of the Bankruptcy Code. If you have any passing interest whatsoever in safe harbor, you must go read immediately this decision by Judge Zagel in the Sentinel case. Then in Hostess, the bankruptcy judge there handed down a decision ruling that an arbitration clause is not enforceable when it deals with a dispute over cash collateral. What is important about this decision is that Judge Drain differs with some of his brothers and sisters on the bench about situations in which arbitration clauses can be overlooked. So it is, although an oral opinion, I think important, going to be cited a lot.
All right, good stuff. Bill, thanks for that. That's Bloomberg News bankruptcy columnist Bill Rochelle. If you'd like to learn more about the cases and issues we just discussed, be sure to go read his column. It's available on BloombergLaw.com and also on the Bloomberg Terminal. I'm Pacchia. Thanks for watching.